Video lecture 8. We are moving into the next area of one of the four fundamental freedoms that are so essential to the internal market. Last week we talked about goods, free movement of goods, and this week we're going to continue with the free movement of persons and union citizenship. So here we see some of the key pictures that symbolize or link to the topic of this week. People moving around Europe. On the left, we see a copy of a residence permit. Next to that, we see a police officer, and we see some workers, builders, and they all have their own link to what we are discussing today. Essentially, free movement of persons and citizenship. So, what does it look like? The outline of today's class. We start by saying some words on union citizenship. Then we move to the free movement of persons, general, let's say, articles that are relevant for this. Then we go to residence rights, and then we go to the workers, the specific category of the worker. And finally, we go to exceptions for public health and public policy. So these are restrictions to the free movement of persons. Obviously, FMOP stands for free movement of persons. Okay, let's start with union citizenship. Well, congratulations to most of you. Should you have an EU passport, then you also have union citizenship. You are an EU citizen. Now, maybe this is not very special, it doesn't feel very special to many of you. You might, in first instance, feel French or German or Dutch or Italian or whatever. Yeah, you are also an EU citizen, meaning that you officially have the citizenship of the European Union, which is interesting in itself, of course, because it also, again, underscores this idea that the European Union wants to move away from this technocratic economic character to a more, let's say, political character, and yeah, something like a state even. A state has citizens. Anyway, the concept of union citizenship can be found, the legal basis for that, in Article 20 of the TFEU. And there we see literally the text is from the article that every person holding the nationality of a member state shall be a citizen of the Union. And it's additional to your national citizenship. So that's basically what I just said. In Article 21, every citizen of the Union shall have the right to move and reside freely within the member states, subject to limitations and conditions laid down in the treaties and by the measures adopted to give them effect. And of course, these measures adopted to give them effect, secondary legislation, directives, regulations, and so on. But the key right and the fundamental right that is attached to union citizenship is the right to move and reside freely in other member states. And that's why it's so easy for you, if you are an EU citizen, to move and go around Europe and to study elsewhere, and if you want also to work elsewhere. If we look at the legal basis for legislating, so for adopting secondary legislation, remember the whole concept of the legal basis one more time, a bit of repetition. Now we have the attribution principle, the principle of conferral, powers have been conferred upon the Union, and that's the basis for making legislation. Then the power is with the EU to create new rules, to create secondary legislation, and remember the legal basis is always to be found in the primary legislation, which is the TFEU usually. So there we are, Article 21, second paragraph. The Council and the European Parliament have the right to adopt secondary legislation, and they use the ordinary legislative procedure for that. And so they basically can, on the basis of Article 21, they can adopt legislation to give concrete content and concrete rules about what these rights of residence actually are, and other rights connected to citizenship. Look at the second part here. Every citizen of the Union shall have the right to move and reside freely. That's the same article we just saw. And so again, that's the core essential right of Union citizenship. Let's take a closer look at the free movement of persons now. Again, some examples of what these persons are. And we see on the left top corner, we see some people that work as doctors or construction workers or whatever. On the right top corner, we see students, such as yourselves. Well, these ones, they are already graduating, so that's still in the future for you. And under at the bottom we see pensionados. I think I googled pensionados. So this is according to Google what you get when you're looking for people who have retired. The good life, it seems. All right. Basically, the first thing we need to be aware of when we study the free movement of persons is that, yeah, it's all nice. We are union citizens. We have this right to move and reside freely, but we're all equal, but some are more equal than others, of course. Basically, we have to distinguish between economically active and economically non-active persons, EU citizens, because the ones that are economically active have more rights. It's that simple. So if you look at this graphic illustration, you see Article 21 gives this basic right to move and reside freely, but it distinguishes, or on the basis of that article, we find distinctions in secondary legislation between economically active and economically non-active persons. For example, workers, people that have a contract with an employer in a different member state. In Article 45 you find the basic article for that. We'll discuss it later on in more depth. They have different rights, they have specific rights, extra rights as workers that you do not have if you're not a worker. Service providers, someone who provides a service over the border, for example, a mobile hairdresser that lives in the border area and also cuts hair somewhere in Germany. That is provision of a service. That person also has other rights, extra rights that we will be discussing today. You can find the basics in Article 56 to 62. Then we have established persons. So these are persons that are abroad, so in a different member state for a longer time, establish themselves, so there's some element there of durability, they stay there longer and so on. And you can also think of companies, of course, that establish themselves elsewhere. So actually that's the more common thing to keep in mind. So let's say I have a company here in the Netherlands and I branch out to Italy. Then I set up there my subsidiary, for example, and I establish myself there as well. Then we have, in the non-economically active category, we have students. Article 165, 166, of course, you cost money. It's of course a bit nasty to say that, although I have to say many of you also work, sometimes a bit too much even in terms of having time to study as well, which is sad. But anyway, that's a different discussion. But students, in principle, they cost money. They're not economically active. They are basically investing in their futures. In the future, they will become economically active and become workers or established persons or service providers. And then we have the retired persons. Basically, their only article is Article 21 that you know, the citizens article, and then the rest category of other economically inactive citizens, also covered by that article. Now, this is the foundation of everything we're going to say today, and basically we're going to zoom in into some of these mainly economically active categories. To start with something very important, with a very important directive, a very important piece of secondary legislation, and that is Directive 2004/38. And this is a directive we will be using extensively during the seminars, also in class, starting today. And I strongly recommend you look up this directive. Just Google Directive 2004/38 PDF. Pop, you get the directive and you read it. Maybe not entirely because it's a bit long, but at least start with the first articles and look at the structure, and you will see that a lot of what we will be saying today, a lot of the rights that are attached to union citizenship and to different categories of people, economically active and inactive, are laid down in that article, in that directive. So what you find there, for example, is that you have up to 3 months, you need basically nothing. You can just travel to an EU country and you can stay there for 3 months, no problem. You just need a passport or a valid ID card, that's it. If you want to stay longer than 3 months in a different EU state, then you will have to be either a worker or a self-employed person, so someone established him or herself, or tries to establish him or herself there, or provide services there, and so on. Or you're a student, and you know all about that. If you're a student on Erasmus, for example, you need to be enrolled in an accredited institution, and then you are also covered for more than 3 months. If you're not an economically active person, then you need to show that you have sufficient resources. So you need a good bank account, and you need to show that you are insured for health, because that's of course a potential big expense if somebody falls seriously ill, and the host state is confronted with the costs of that citizen who's from a different state. That's a problem. So health insurance is also required. If you stay for a period of 5 years uninterrupted in a host member state, you can get permanent residence. Yeah, so you basically get you becoming almost fully protected as a normal citizen of that host member state. So it's a very important goal to achieve. 5 years of uninterrupted residence. Doesn't mean you can never leave the country. You can actually leave. I think, well, you can look it up in the directive, but I believe it's until 6 months, a year, you can stay away within that 5 years period. Yeah, but you have to take that into account, of course, that you don't stay away longer, because then you lose the build-up of these 5 years. Important is that this right to permanent residence also extends to your registered partner or your spouse if you're married, and children that are dependent on you under 21 years, and also people in the ascending line that depend on you. A couple of illustrations. So here, the next slides, we go through, I think it's 3 cases where we illustrate what the Court of Justice of the European Union, or the EU's Let's now go to some case law, where we look at some interpretations of what the citizenship and the rights for residence rights and so on, what they actually mean, and rights to social assistance in practice in some cases. Because you know that this topic of people from one member state moving to another member state, and potential implications this has on the welfare state of the other host state and so on, that this is a very hotly debated topic. It was one of the main topics in the Brexit discussions, for example. So let's look at some examples. The first one is Ruiz Zambrano. It was about 2 Colombian citizens that fled Colombia, went to Belgium, didn't get asylum, but they got 2 children while they were in Belgium, and these children had the Belgian nationality. They became Union citizens. They fall under Article 21. Now, the question was, what does this mean for the parents? Can they be sent away? And they did not get asylum, but they did have these babies, these small children that were Belgians. What kind of implications did that have? The Belgian state wanted to actually send them away. The case went to court, and the court in Luxembourg was asked to interpret this situation in the light of union citizenship. Now, the problem here was that Directive 2004/38, and that directive we just talked about, and this very important directive, didn't apply because the Zambranos didn't move around the member states. So there was technically not a situation of union citizens that moved to a host state. They were in Belgium. The kids, they were there with their parents. It was a Belgian case. So Directive 2004/38 wasn't triggered. So all these guarantees in that directive did not apply. However, the court interpreted Article 20 of the TFEU to prohibit measures, national measures that will have effect of depriving EU citizens of genuine enjoyment of their citizens' rights. So the fact that these 2 small kids, the Zambrano kids, were Union citizens, gave them protection to genuinely enjoy their rights, and sending their parents away from them, which effectively means that they would lose all their rights, was seen by the court as violating this protection. So a refusal to grant the right of residence to a third country national, so the parents, with dependent minor children in the member states where those children are not nationals and reside, and also refusal to grant such a person a work permit has such an effect. So this is a very important case in the sense that it was opening up all this protection under Article 20 for dependent children who are EU citizens with parents who are not. Let's go to the next case, the Dano case, which was also very much in the news at the time it occurred, also in view of the Brexit talks and David Cameron's campaign to try to stay within the EU. It was about a lady, Dano, a Romanian national, and she has 2 children, lives in Germany, is unemployed, also didn't want to work. And she claimed social assistance from the German state. Now here you see this classic tension that I already introduced a little bit, that member states are afraid of course some member states, especially the richer ones, is that they will attract a lot of persons from other more poor member states, and that these persons, these citizens, will claim social benefits under their system. That's of course was one of the key drivers in the discussions on Brexit, that this is a very serious problem. The German state refused the social assistance. The case went to court. The interpretation of the court was that Directive 2004/38 allows member states to refuse social benefits to economically inactive citizens to avoid that they become a burden on their welfare systems. Yeah. So if you look at Directive 2004/38, you will find there that it's possible for member states to not give social assistance to economically inactive citizens of other member states, for them not to become a burden to their national systems. So that risk was averted in that case. But then we had the Alimanovic case, which was similar to the Dano case, but with a very important difference, namely that Mrs. Alimanovic did work in Germany. She had 3 children. They all had the Swedish nationality. She worked in Germany for 11 months. Then she lost her job. She didn't want to. So a very different case from Dano. She lost her job. She wanted to work, but she couldn't. Then she retained the status of worker for another 6 months. This is actually also a key, let's say, policy, that the status of worker, and we'll say a bit more about what a worker is in a moment in the next one of the next slides. But if you lose your job, you still have this status of worker for at least 6 more months. So during that time she received social assistance. But then she lost her worker status and also her social benefits, and that's what she tried to fight for in court. Here the court said, well, Directive 2004/38 allows for establishing a gradual system with regard to retention of the worker status, which seeks to safeguard the right of residents and access to social assistance. This is this extension of the 6 months period. The legislation in Germany, the member states legislation, that's the last point, that grants a right to social assistance for a period of 6 months after the cessation of employment, so when the employment stops, would guarantee a significant level of legal certainty while complying with the principle of proportionality. There we have it again. So it's written down here a bit complex language. That's unfortunately the language of the EU's institutions and also the court. Basically it says that Germany could say to Alimanovic, you don't get social assistance anymore after 6 months. Because the system they had with this extra 6 months after losing the job, still having social assistance, and then stopping it basically, that was proportional, and that was in line with legal certainty. So this is something that someone can know and can anticipate on in this 6 months that she or he has after the job stops. Okay, so basically that's about the cases, and we saw in the Zambrano case a very active court that opened up a lot of protection for the Zambrano family, and in the other 2 cases we saw that the fears of having, let's say, other citizens from other member states abusing or overusing the social assistance systems of host member states was actually interpreted conservatively, and there was not the member states were actually able to limit the access to their social assistance. A little bit about the definition of worker now. If you look at Article 45, you can find what a worker is, and remember Alimanovic was a worker. Now, this is an important status to have. There's a separate regulation for it, 492/11, please look it up and you will find what it is about. When is someone a worker? Because it gives all these rights, it's important to establish when someone is a worker, because then you know that you have all these rights, so it has important effects. First of all, to be a worker you have to be an EU citizen, so you have to have the nationality of one of the other member states. Then the next point is you have to perform genuine and effective activities. That's the second criterion. Now this criterion has been performed rather extensively. So in order to reach the threshold of genuine and effective activities, not that much is needed. Also part-time jobs, for example, are under the worker criterion. That's not the reason why I put this guy who's asleep in front of his keyboard there, but yeah, maybe it is helpful if you look at that. You think, okay, to reach the threshold of worker, and we're not talking about very excessive requirements. And the next point is that this person has to be remunerated for it. So meaning that you get a salary and you have an employer that supervises you. So you have a boss basically. Yeah. So that's another essential point. So EU citizen, effective and genuine activities, and you have a boss and you get a salary. If that's there, then you are a worker and you are covered by the protection of the workers article. Now what does it mean? What kind of rights do you have if you're covered by this article and by the regulation? Well, of course, a very important point is that there shouldn't be any discrimination between you as a foreign worker from another EU member state and the domestic workers. So you have all the same rights. So remuneration, salary, the right to remove freely, and basically apply for jobs. There can't be any distinction there either. That is all what is covered there. Same for salary, secondary benefits, how to be fired, dismissal arrangements, social fiscal benefits, labor union activities. You can be a member of the labor union, yes or no. So basically, this is all the same. It should be the same for the Dutch employers, employees, and the foreign ones. Now, here at European Studies, we have many colleagues from EU member states, other EU member states, and they have exactly the same conditions and the same rights as it should be. Then the point that we already discussed when we discussed the Alin Manowitz case, a right of residence also exists after employment contract ended for no less than 6 months. Yeah, well this is, well it's slightly different actually, but anyway, so you can still stay for 6 months in the member states, the host member state. Article 7 you can find it, and that is basically because they say, well, you have to have a reasonable time to get your act together, to maybe if you're fired, you lose your job, to find another job, or yeah, that's basically it. Yeah, so in order to have a real, genuine chance to get work, to find new work, you need that time. All right, now a little bit to the exceptions now. And we always follow a similar pattern. We start with the articles, what is it? When do you qualify, what's the definition, and then we go to the exceptions. So here also exceptions, and you see again we use Directive 2004/38, and a very important directive, as we said before. So what are the exceptions? Now, very common sense, logical exceptions. I invite you to use your common sense here as well, and to just think, okay, what could be a justifiable exception to free movement of persons? Well, if someone is dangerous, a terrorist, a criminal, someone is very ill, has a contagious disease, blah, blah, blah. So if you use that logical thinking, you already can think up all the exceptions. So here we have them presented to you on the slides. First one, we start with the public health exception. If somebody has a contagious disease, of course, you can not allow this person to get into your country. Yeah. If the infection occurs after a 3-month period after arrival in the country, then you cannot just kick them out anymore. And that's basically, you've become the problem, the owner of the problem after these 3 months. You can find this in Article 29 of the directive, and we will be practicing with this on the in the seminars. Then we have some rights. Offer for a medical inspection free of charge. That is if there's a suspicion that somebody is sick. Yeah, and that's also to be found in Article 29. Then we have the other exception category, and that is public policy and security. Of course, a very important one nowadays with the increasing threats to public safety, mainly due to terrorism. So, can a member state deny a citizen of another member state entry into the country? Yes, that is possible. But, of course, we have some conditions. So the measures must comply with the principle of proportionality. So again, if you want to say someone cannot come into the country, you have to have a very good reason for it. You have to have a convincing reason. It has to be proportional that you say no to someone coming into your country. It should always be about the personal conduct of the individual, and if somebody has been convicted in the past of some crime, that is not in itself enough to say no, you can't enter the country. Yeah. So Article 27. There must be, that's the next point. The conduct of the person must represent a genuine, present, and sufficiently serious threat to one of the fundamental interests of society. Yeah? You cannot deny someone entry just to set an example. It has to be, and that is what is meant by, you cannot rely on considerations of general prevention. So you always have to say, you, this person, Mr. von Münster, you're not allowed to go into France because you present a genuine threat to our public order because you have done whatever. And let's assume that I'm a crazy extremist and I've said all kinds of threatening things that I would attack the French state. And then I travel the next day on a plane, and at Schiphol Airport they tell me, sorry, you can't board the plane because, well, Article 27(3) of Directive 2004/38, you present a genuine, sufficiently serious threat to our public order. This happened, for example, to Geert Wilders, if you remember, some years ago, a long time ago already, maybe it was 2012 or so, when he wanted to visit the United Kingdom to talk to the House of Lords there, and he did not, he wasn't allowed in because, well, the reasoning was he presented a genuine and sufficiently serious threat to public order in the UK. Two cases, yeah, they're still on the slide because they give you, we used to have more information on this, but it was just to show you how this works out in some concrete cases. The first one is a bit of a weird one. Yvonne van Duin was about interpretation of the personal conduct of the person involved. Yvonne van Duin is a Dutch person who wanted to work for the Scientology Church in the United Kingdom. She accepted a job and wanted to go to the UK to start working for this organization, but then she didn't get a work permit because the United Kingdom said, sorry, we find this organization, Scientology Church, you may know it from what's his name again, Tom Cruise and John Travolta, the famous Hollywood actors who are a member of this church. It's a bit of a special organization, let's put it like that. They ask for a lot of money of their devotees, and it's also hard to leave the church once you're in, and they also threaten people and so on and so on. The problem there was that it was a bit of a strange outcome because in Yvonne van Duin case, because the court said, yes, UK, you cannot give this workers permit to Yvonne van Duin, but at the same time they did not outlaw the organization within their own borders. So it was a bit of a strange double approach that the UK had there. In the Adaoui and Cornouailles, I think you pronounce it like that, sorry if I don't pronounce it correctly, case, it was a case about two French women who worked in a bar in Belgium, and they worked there, let's say, in a not very decent profession, you get it, they were prostitutes, and they were expelled from Belgium. So there the problem was that the court said you cannot just simply expel people who do this kind of job if you do not treat your own citizens in a similar way. Yeah, so you cannot expel your own citizens, of course, but at least you have to also have some effective measures against them, and that are sort of the same severity as sending someone away back to their countries. Yeah, and this was not the case. So there was basically a form of discrimination going on there between nationals who were prostitutes and foreigners who were prostitutes. So here again you see this importance of this non-discrimination principle. Then we have a further exception, and that is for the category of workers. As I said before, you have certain rights as workers. You can do the same jobs, you have the same salary, you can become a member of the workers' union, and so on and so on. But there's an important exception here for public service jobs. Some of these jobs, public service jobs, they can be reserved only for nationals. And those are the jobs that are about power, exercising power, conferred by public law, and have basically an element of safeguarding a fundamental interest of the state. So you can think of police officers or judges and so on. Yeah, so that's why these people are always Dutch citizens and not French citizens or Spanish citizens. Yeah, so there is always this category of workers that are of jobs that can be reserved for nationals. Makes sense. You could say, is that not discrimination? Well, it is discrimination, but on a good ground. Huh? Basically safeguarding the interest of the state. All right, we're done for this week. Next week we're going to talk about the free movement of services and establishment. And after that, competition law, and then we reached the end. So this was the second fundamental freedom of the internal market. After free movement of goods, today we talked about free movement of persons. Bye-bye.